a very warm welcome to all of you. This entire DNA video series it's brought to you by LawSikho, and in today's video we've combined news updates for 2 days. So in this video you can have access to the news updates for the 19th and for the 20th of October. So let's start with the DNA and let's have a look at the agenda sheet for today. First of all, as you know, we have the editorial segment, and here for today's discussion we've taken up an Indian Express article, the title of which is this: Scriptures may be copyright free, but adaptations they are protected. You know, this title, it has very beautifully summarized the High Court judgment because the very core of the High Court's pronouncement is this only. Scriptures per se, they may be copyright free, but when it comes to any adaptation, any interpretation, any translation which has any creative take in it that has been done by any person of these scriptures, let's say any modern translation of the Bible, then that would come under transformative work, which is a category protected under the Indian copyright law. And let's say there is a third person. This third person creates a reproduction of this adaptation without the permission of the author. So then that would be a copyright infringement or violation as per our law. Secondly, we're going to have a look at important news updates, and this is going to be followed by the last segment where we talk about important legal news. So without further ado, let's start with the article. And before we start with the facts of this case and the High Court's ruling, I think it is imperative upon us to understand the legal position so that we understand this case in a better, nuanced manner. So let's address this proposition of law first. Are religious texts protected by copyright? See, religious scriptures, they are in the public domain. And in copyright law, no exclusive intellectual property rights, they apply to creative works which are out there in the public domain. So the answer to this would be no. Religious texts, because they are out there in the public domain, so therefore the copyright law, it does not allow giving them exclusive intellectual property rights. However, there is this one thing that we need to understand. If there is any sort of modern take, any adaptation, any interpretation of these scriptures, so then that would amount to be a transformative work and it is going to be covered by the copyright law. So for instance, the Old Testament and the New Testament, or the King James Version of the Bible, which is one of the most widely used translations of the Bible, they are not protected by the copyright law. However, many modern translations of the Bible, they are copyright protected because they represent new creative works by the translators. So for example, the New International Version, which was first published in 1978, it is protected by copyright law and permissions would be needed, or the terms which are set out by the holder of the copyright work, they would have to be followed in order to use this particular version text for certain purposes. Another example would be this, that we have scriptures in the form of Ramayana and Mahabharata. So they are not protected by the copyright law. However, there are television series which are based on these scriptures, and these television series, they are transformative work and they would be protected. As far as the Indian law on copyright is concerned, two forms of protection are given, that is, two types of works are protected. The first one is the original work and the second one is the transformative work. What is an original work? As the name itself suggests, a creative and independently created expression which is fixed in a tangible medium. The law, it grants the creator and the author of this work the exclusive right to use, to reproduce, to distribute, perform, and display their work. Now, what is the second category, the transformative work? This is a creative and artistic work that takes existing material, be it in the form of a text, music, or any other art form, and significantly modifies or reinterprets or build upon it so as to create something new and distinct. So there is value addition in form of any creative take on the already existing work. Now that we're clear with the legal position, let's go back to the factual matrix of this case. Now, the Delhi High Court, it has found large-scale infringement in the reproduction on the internet of the copyrighted work of a book trust. The name of this book trust is Bhakti Vedanta Book Trust. So what does this book trust do? It essentially publishes books and commentaries on the Indian religious philosophy and spiritualism, especially classic Vaishnava texts. In its order, which is dated 21st of September, Justice Pratibha Singh of the Honorable High Court of Delhi, she allowed the trust to approach tech giants like Google and Meta, who own YouTube and Instagram respectively, with takedown orders against those who are reproducing the copyrighted works on Srimad Bhagavad Gita. So this is the reproduction of copyrighted works on Srimad Bhagavad Gita. So what is this copyrighted work? That is the segment for next slide. Now here a little bit of information on the trust. It was established in 1970 by the founder of the very popular, now popular Krishna movement, which is the ISKCON organization, Srila Prabhupada. So he did or created some work on Srimad Bhagavad Gita and other religious texts in very simple language. So he explained those texts in simple language so that common man could understand. And there is reproduction of his work by certain entities without express permission of the trust. And therefore the trust approached the court that you give orders to take down these reproduction on the internet. So let's understand as to what is the case of the petitioner. The trust, it said that its founders' works published in various Indian and foreign languages. It had simplified the religious books and scriptures, making it very easy for layman or common man to understand. The copyright of his work, it would vest with the trust after he died in 1977. The trust, it claimed that certain websites, mobile applications, and Instagram handles, they were making available a large number of the trust's copyrighted works almost in the verbatim manner, which is word to word manner, on their online platforms without their permission, and therefore this is amounted an infringement of the copyright that they have in this work. So let's understand now as to what did the High Court say. In its interim order, the court said that the adaptation of the scriptures, including the explanation, the meaning, the interpretation, or creating any audio video works, it would be entitled to copyright protection. The court further said that this is because these are the original works of the authors themselves. The court further added, and I quote, "Thus, there can be no objection in the actual reproduction of the text of Srimad Bhagavad Gita or similarly other spiritual texts or books. However, the manner in which the same is interpreted by different gurus and spiritual teachers, so if there is any guru or spiritual teacher and he has interpreted these texts, then copyright it would be vested in respect of the original parts of the literary works which preach, teach, or explain the scripture," the court said. Further, the court added that since Srila Prabhupada, he had himself handed over the copyrights to be administered by the trust, therefore the works, they cannot be reproduced without authorization, without any sort of license or the permission of the trust. The court found that the shloks in Prabhupada's books as well as their anuvad, which is translation and intention, it had been reproduced by the different entities, which is the defendant entities. Therefore, the court agreed that if not checked, such piracy, it would cause an immense loss of revenue to the trust. And now we proceed to the next segment for today. And now we proceed to the national news category for today. And here, this is the very first update. 3rd Naga Regiment, the honored custodians of the President's color. General Manoj Pandey, the Chief of Army Staff, he presented the prestigious President's Colour to the 3rd Battalion of the Naga Regiment during an impressive colour presentation parade. This parade it was held in Kumaon Regimental Centre in Ranikhet in Uttarakhand on 13th of October. After reviewing the parade, the Army Chief appreciated the rich traditions of the Naga Regiment in all the spheres of military activity, be it operations, training and sports. Udhampur Military Station, it gets the Best Green Military Station Award for the year 2023. The Udhampur Military Station, it has bagged or secured the award of the Best Green Military Station Award, the Army has stated. The Best Green Station Award, these were represented and presented by the Army Chief General Manoj Pandey at the Army Commanders Conference. Apart from Udhampur, Dehradun Military Station, it also secured the similar award in the second spot. Also, Bikaner Military Station, it was awarded the Best Transformative Station trophy. Now let's have a look at some information on the Army Commanders Conference. So this conference, it began on the 16th of October and it is scheduled to conclude on the 20th, which is today. It is an apex level biannual event. It is an institutional platform for deliberations at the conceptual level, facilitating important policy decisions for the Indian Army. This conference, it serves as a very crucial platform for high-ranking military officials to engage in strategic discussions that lead to significant policy decisions for the Indian Army. UP gets first robotic process automation lab under the Future Skill Prime project in Gorakhpur. The first robotic process automation lab under the IT Ministry's Future Skill Prime project in Uttar Pradesh, it has been set up at the National Institute of Electronics and Information Technology at Gorakhpur. The lab it was inaugurated by the Secretary of Ministry of Electronics and Information Technology, S. Krishnan, during the 26th All India Directors Meet of the National Institute. Mr. Krishnan, he said that this lab, it is going to play a very pivotal role in transforming India into a global technology powerhouse. He also emphasized the role of this lab in improving services to citizens by automating repetitive and manual processes such as data entry and verification. So the benefit of this automation would be this, that there is going to be a reduction of clerical and human errors and the response time is going to increase and there is going to be increase in the efficiency. Also, during this event, Deen Dayal Upadhyay University, Gorakhpur, its Vice Chancellor and the Director General of this institute. So they've signed an MOU for conducting employment-oriented courses and training in future skill technology in Gorakhpur region. This is going to play a very important role in equipping the candidates with industry-oriented skills. CCI, it approves merger of IDFC Limited with IDFC First Bank. Fair Trade Regulator, which is the Competition Commission of India, it has approved the merger of IDFC Limited with IDFC First Bank. The IDFC First Bank, it is in the business of providing banking services, while its parent, which is the IDFC Limited, it is an RBI registered non-banking financial company. The deal, it is subject to conditions including the merger of IDFC Financial Holding into IDFC Limited in the first step and subsequently the amalgamation of both of these entities. Further, the Commission, it also approved the cancellation of the existing shares held by IDFC Financial Holding in IDFC First Bank and then the issue of new shares of the bank to IDFC Limited's shareholders. Two Indian Railways PSUs, they have been granted and bestowed with the status of being Navratna companies. IRCON International Limited and RITES Ltd, Both central public service enterprises under the Ministry of Railways, they have been announced as the 15th and the 16th Navratna respectively among the central public sector enterprises. The Ministry of Finance on Thursday conferred the Navratna status on both of these entities. As far as RITES Limited is concerned, entering the 50th year of its incorporation, it is a leading transport infrastructure consultancy and engineering firm in India. It provides services in the diverse sectors of transportation, railways, export of rolling stock, highways, airports, metros, urban engineering and sustainability, ports and waterways, and energy management. Entering the 47th year, IRCON, it is in railways, highways, and extra high tension substation engineering and construction. So, this is the competency of this entity. The company, it has executed projects which are operated in the areas of railway construction. NDDB chairman, he has been appointed on the board of IDF. Dr. Minesh Shah, the chairman and the managing director of National Dairy Development Board, he was elected to the board of International Dairy Federation during the General Assembly of IDF on 15th of October. Accepting his responsibility and thanking the Federation delegates for the trust that was bestowed in him, Dr. Shah, he mentioned that a representative from India, a country that contributes as nearly as 23% of the global milk production, is on the board of the Federation, which will ensure a more inclusive and better global dairy ecosystem. This will also help putting forth the voice of millions of dairy farmers from the smallholder based dairying system to the global forum and help design suitable policies, frameworks, systems, and process. Here I have a question. Which directive principle of state policy it provides for establishment of animal husbandry, organization of animal husbandry on scientific layers and grounds and scientific lines, and further prohibits the slaughtering of cows and other milch animals. And also the further question, and in fact the most important part of this question is, this particular article, it has been categorized in two different categories. So I'm sure that all of us know that the directive principles, they've been in the interpretation, they've been classified into three categories: the Gandhian, liberal, and socialist directives, DPSPs, right? So this particular article, which is this article first, and second, this article has been classified into two of these categories. So, what are those two categories and which part of this article belongs to which category? Please put down your answers in the comment section. Moving on to the next update. Build space station by 2035, send an Indian to the moon by 2040, says the Prime Minister. Prime Minister Shri Narendra Modi has recently announced a very bold vision for India's space exploration efforts, aiming to establish its own space station by 2035 and send an Indian astronaut to the moon by 2040. This announcement, it came during a high-level meeting that was convened to assess the progress of the Gaganyaan mission, which is India's ambitious human space mission. During the meeting, the Prime Minister who chaired the session, he presented a strategic roadmap for India's future in space exploration. The gathering, which included top space agency officials, it reviewed the readiness of the Gaganyaan mission and confirmed that the launch of the country's first human space mission, it is scheduled by the next 2 years, which is 2025. Building upon the recent success of Indian space endeavors, including the Chandrayaan 3 and the Sun mission, the Aditya L1 missions, Prime Minister, he directed the Department of Space to set their sights on the more ambitious goals. The new objectives they include establishing an Indian space station named the Bharatiya Antariksh Station by 2035 and achieving the milestone of sending the first Indian to the moon by 2040. India to send 446-member contingent to Asian Para Games. India, it will be represented by a strong 446-member contingent, including 303 athletes at the 4th Asian Para Games to be held in China from 22nd to 28th October. The Sports Ministry, it has sanctioned a total of 303 sports persons, 191 of which contains male members, while 112 being females, across 17 sporting disciplines and categories for the Asian Para Games. Besides the ministry, it also cleared a total of 143 coaches, escorts, officials, and support staff. Out of the total number of athletes, 123 they will only take part in athletics events. This is the biggest contingent in that India has ever sent for the Asian Para Games. If we have a look at the data from the last edition in Jakarta, a total of 190 athletes represented India in 13 sporting categories. Now this time there is going to be 17 sporting categories, returning 72 medals, including 15 golds. Ashutosh Sharma, he breaks Yuvraj Singh's historic record for the fastest 50 by an Indian. Ashutosh Sharma, a middle order batter for the Railways, he recently shattered or broke Yuvraj Singh's long-standing record for the fastest 50 by an Indian cricketer. In the Syed Mushtaq Ali Trophy Group C match in Ranchi against Arunachal Pradesh, Ashutosh he smashed his half century, 50 runs, in just 11 balls, breaking Yuvraj's 16-year-old record set during the inaugural T20 World Cup in 2007 when he reached his 50 in 12 balls against England. I'm sure all of us who are in our mid 20s, we remember this particular game where Yuvraj Singh he hit six sixes in an over, and in just 20 balls he hit the half century. Ashutosh, aged 25, he came to the seas after Railways lost their fourth wicket and wasted no time in going after Arunachal bowlers. India and UK hold inaugural 2+2 dialogue, paving the way for potential Rishi Sunak visit. India and the United Kingdom, they convened their first 2+2 foreign affairs and defense dialogue in New Delhi, a critical step in strengthening their comprehensive strategic partnership. The dialogue, featuring senior defense and foreign policy officials from both the nations, it explored avenues for cooperation in a wide range of areas. The 2+2 dialogue, which typically involves discussions at the level of senior officials or ministers, it is a framework India reserves for its closest strategic allies, including the United States, Japan, Australia, and Russia. The meeting in New Delhi, it reflects the growing importance of India-UK relation and their shared interest. During the discussions, both the sides deliberated on the possibility for collaboration and cooperation in various domains, including trade and investment, defense, critical and emerging technologies, civil aviation, healthcare, energy, culture, and enhancing people-to-people connection. The two nations, they are keen to expand their cooperation in these sectors with an eye on fostering economic growth and innovation. 5 Central Asian nations to join India-Iran-Russia corridor, says the NSA Ajit Doval. The National Security Advisor, he has said that all the 5 Central Asian countries, they will become a member of the India-Iran-Russia corridor, the International North-South Transport Corridor, inviting all the Central Asian countries to fully utilize the Shahid Beheshti terminal in Chabahar in Iran, operated by the Indian company. Doval, at the second meeting of the India Central Asia NSAs, which was held in Kazakhstan on Tuesday, he solicited support for including the Chabhar port within the framework of the International North-South Transport Corridor. In the absence of direct land access between Central Asia and India and anomaly, he said that this was due to the conscious policy of denial by a particular country. Now we come to the international segment for today. US imposes new sanctions on Iran's missile and drone programs. The US, it is imposing new sanctions targeting Iran's missile and drone programs in a move which is aimed at countering Tehran's threat to Israel and allies in the Gulf, as well as the destructive impact of the weaponry in Ukraine. The US, it is also issuing guidelines and guidance to industry on guidance. I'm sorry. So the US is issuing guidance to industry on components which is sought by Iran to boost its missile program. In a statement with 45 countries, including the UK and other European allies, Washington cited mounting concerns about the country's missiles and drones and their provision to partners and proxies, which endangers international stability and it escalates regional tension. Hamas, which carried out the deadly assault on Israeli civilians last week, it is backed by Iran, as is Lebanese-backed Hezbollah, which is threatened to join the fighting between Israel and Hamas. And this has brought us to the last segment where we talk about 4 legal updates. Let's first start with this update, which is an important one. So the Supreme Court has issued a slew of directions to the Union government and all the state and UT governments to ensure the effective implementation of the provisions of the POSH Act, which is the Sexual Harassment at Workplace Prevention, Prohibition and Redressal Act of 2013, read with its rules. Significant among them is the mandatory direction which is issued by the court that the states and the union territories, they must appoint a district officer as per section 5 of this particular act. Though section 5 it says that the appropriate government may notify a district magistrate or additional district magistrate or the collector or the deputy collector as a district officer, the court read this as a mandatory condition. The bench, it passed these directions in a writ petition which was filed under Article 32 of the Indian Constitution by an organization which is called the Initiatives for Inclusion Foundation, seeking effective implementation of the provisions of the POSH Act. So since this was the organization which brought this case before the Supreme Court, so the name of the case is Initiatives for Inclusive Foundation versus Union of India. Next up is an update from the Apex Court itself. So in a notable judgment, the Supreme Court has held that unilateral revision of fees by an arbitral tribunal, though not permissible, it will not terminate its mandate on the ground of ineligibility as per Section 12 of the Arbitration and Conciliation Act. Although the Supreme Court has held in another 2022 case, which is Oil and Natural Gas Corporation Limited versus Afcons Limited, that the arbitrators, they should revise the fee only in consultation with the parties and should not do it unilaterally, a bench of Justices S. Ravindra Bhatt and Arvind Kumar, they held in the present case that a breach of the rule which is laid down in this particular case, ONGC case, it will not render the arbitrator ineligible. The name of this case is Messrs. Chennai Metro Railway Limited versus Messrs. Trans-Stolen Stroy Afcons JV. Here I have another question, whether ONGC is a state under Article 12 of the Indian Constitution or not, and whatever your answer is, please cite the case law supporting your answer. Moving on to the next update. Consumer disputes, they are non-arbitrable. Consumers, they cannot be compelled into arbitration. This is the Apex Court holding. So the Supreme Court has recently held that consumer disputes, they are non-arbitrable disputes and a party, it cannot be compelled into arbitration just because they are a signatory to an arbitration agreement. A bench of Justice Sanjay Kishan Kaul and Justice Sudhanshu Dhulia observed that the Consumer Protection Act, it is a piece of welfare legislation and its primary purpose is the protection of the interest of a consumer. The apex court further observed that a party to a dispute cannot be compelled to resort to arbitration merely because it has been provided in the contract to which the party is a signatory. When one of the parties seeks redressal under a welfare legislation, then the arbitrability of the dispute, it needs to be considered, the court said. The name of this particular case is M. Hemlatha Devi and others versus B. Udeshri. Moving on to the next update, which is in the case of Priyanka Kumari versus Shailendra Kumar. So here the Supreme Court recently held that when notice is returned as unclaimed, then it shall be deemed to be served on the addressee and considered proper service. The apex court, it also clarified that the word refusal, it can be interpreted as synonymous to the word unclaimed. In the matter at hand, notice issued to the respondent, it had returned with the remark unclaimed. So the registry in its office report had mentioned that when the notice is returned as a refusal, then it constitutes complete or proper service. But when it is returned as unclaimed, then it is considered incomplete service. So in this respect, the court held that the word refusal, it can be interpreted in synonymous to word unclaimed, as was held by the Honorable Supreme Court in the above decision, which is this: when a notice is served to the proper address of the addressee, then it shall be deemed to be served unless the contrary is proved. Thus, when the notice it is returned as unclaimed, then it shall be deemed to be served and it is proper service. And this has brought us to an end of our TNA for these 2 days. Thank you for being with us. And in case you want to get in touch with LawSikho, these are the point of contacts for the same. And I would highly encourage all of you to join our Telegram channel where you can get access to the TNA and its PDF. So for the same, you may scan the barcode here or click on the link which is made available in the description. And the quiz is also made available via a link in the description itself. Thank you for being with us, and please don't forget to answer the question that was posed in the TNA video in the comment section. Thank you.